Will my case go to trial? This is a question that I get probably 5 to 10 times a week from the many people that want to avail themselves of the service at the Bianchi Law Group. It's a great question, and it's a tricky one, and the answer is going to be, I don't know. Okay, so we'll start over this. Most cases don't go to trial. In the criminal justice system, there is a heavy emphasis on trying to resolve the case by way of a plea agreement without the necessity or need to have to go to trial. When you're listening to a client explain the facts of a case, you're assessing what they're telling you, you're assessing what the charges are or possible charges could be. And there are times when you're evaluating the case where you're saying, well, is there enough evidence in the case, obviously, to prove the case beyond a reasonable doubt to 12 jurors with the understanding that you are presumed innocent. And of course, you have a right to a trial. But let's be real here. The consequences of going to a trial and being convicted can be draconian, depending on the nature, the degree of the crime, and any potential mandatory sentences that may attach upon a conviction. Just to give you a little bit of some history, when I first started, there were only 2 mandatory sentences in the state of New Jersey. And now there's multiple mandatory sentences that are out there, and the legislature has passed laws called 85% or NERA, No Early Release Act offenses. And it just seems to me, and it seemed to me this way when I was the county prosecutor, that every single day in our desire to be quote unquote tough on crime, we keep passing more and more mandatory sentences, which I get in some instances may make sense for certain individuals with certain kinds of crimes, but unfortunately drag into the system many people who don't need to be prosecuted with that level of aggressiveness. It's what I used to call, when I was the prosecutor, hitting a fly with a sledgehammer. Unfortunately, we have to dance with the one we brought, and that means the laws that are there. And with a lot of the charges that our clients are charged with, the consequences of being convicted for those charges are pretty draconian. And that's why prosecutors will often give an incentive by way of a plea agreement, which substantially reduce the exposure that a client faces if they accept the terms of the government's offer. And the question often becomes, for a client who says, I did this, they may not have done the maximum thing the prosecutor said or something in between that, is what is the fair resolution of the case? 90% of the time, we're fighting with prosecutors and judges to try to get to a fairer, more balanced resolution of the case on behalf of the client. Now, if the evidence in the case is weak, and that's irrespective of whether a person's guilty or not guilty, the evidence is weak, then there's more of a likelihood, hopefully, that prosecutors would lower the plea offers even more. And that's why it's important for defense attorneys to work their case up to show prosecutors weaknesses in the case, either legally or factually, because as the case is weaker for a prosecutor, the way it should go is that the plea offer should go down. So even though you may not be at a trial, you have to prepare as if you are going for trial. At least that's the firm philosophy at the Bianchi Law Group, because it accomplishes 2 things. One, it nicks the prosecutor's case, lets them know that it's going to be, what I mean by that, it's going to be more difficult for them to secure a conviction, which hopefully will result in a lower plea offer. And in the event you can't work out a resolution, you're not trying to prepare for a trial at the last minute. So it's very, very important from a firm philosophy point of view to be prepared for that case right from the very beginning as much as possible. Now, one caveat I want to say here that I see going on out there a lot, and it's very regrettable. If you are saying to us, and it's very important that you be honest with your attorney. If you're saying to us, you did not do this, that you were not guilty, that you were innocent of this offense, and we have a number of those cases and been successful on a number of those cases. But I know from the beginning when a client says that they're buying their way into a trial. Why is that? This is really important. It's because before you can plead guilty in the state of New Jersey, you have to give an under oath factual basis to the court as to what it is that makes you guilty. So let me spell this out for you. Your defense lawyer and the prosecutor are negotiating the case. They're going back and forth, and eventually they come to a resolution that you, the client, find to be acceptable. Well, before you're allowed to plead guilty, and we'll go into a little bit more detail on this in another video, you fill out plea forms. Again, we'll discuss that later. And then you go before the court. And during that procedure, the plea agreement procedure, the court under oath is going to ask you, are you guilty of the offense to which you're pleading guilty to? And then they're going to take a factual basis. Now, each court does it a little bit differently. Some courts will ask the defense lawyer to give the factual basis. Some people will ask the prosecutor to give the factual basis. I've actually seen, in some instances, although it's rare, the court elicit a factual basis. But with the factual basis is they want to hear you say the words, I'm guilty because on such and such a date, at such and such a time, I did such and such an activity. If you cannot give a truthful, under oath, factual basis for what it is that makes you guilty of a crime, a judge will not accept the plea of guilty. The lawyer gets to a point where he says, well, you said you're not guilty, that you didn't do this, but if for you to get the plea, you're going to have to tell the judge that you did do it. This is an unworkable scenario because the client has been saying all along that they haven't done it. There hasn't been much investigation. There hasn't been much by way of working the case up. And in fact, in many cases, I've said you can't blame the prosecutor for not lowering a plea offer or not dismissing a case in light of the fact that the defense lawyer is not provided to them the information you're providing to let the prosecutor know that there's problems with the case. The bottom line is the defense lawyer and the prosecutor have come to an agreement. And if you can't give a truthful, factual basis of what it is that makes you guilty, the judge will take the plea. You are going to be headed to a trial under those circumstances. So it's very, very important that you understand most cases don't go to trial. But if there is something that you did not do and that you are innocent of, you're almost guaranteeing that's the kind of case that will go to trial. Also, even if a person is completely guilty of an offense, and I know people may find this offensive, but there's a reason for it and a good reason for it to make sure the government doesn't overwhelm us with the power and resources that they have. It is the government's obligation to prove its case beyond a reasonable doubt to a jury. We'll go into reasonable doubt in another video, and that you are presumed innocent. And if the government does not have that evidence to be able to do that, then if you decide you want to go to trial, and a jury may come back not guilty. I mean, they could come back guilty, but they may come back not guilty. In those circumstances, you put the government to the test by having a trial in the case. So it's an extremely significant decision as to whether or not you go to trial, because if you are convicted, the penalties can be, you're going to be sentenced without the benefit of the plea agreement, which again is substantially less than what a trial conviction would be in most cases. So the decision to go to trial is a very big one for a client, and that's why negotiations are so heavily emphasized in the criminal justice system. However, again, if you did not do it and you can't give a factual basis and you go to an attorney, you need them to say the magic words that they will go to trial on the case, because there will be no other alternative. I hope the video was somewhat instructive. Of course, go to a lawyer that's competent. Go to a lawyer that's an expert in criminal law. Go to a lawyer for sure that's not afraid to go to trial, that's skilled at going to trial, that's respected for their skills in the courtroom to go to trial, because even if the case isn't tried, that skill set will serve you well in the plea negotiation process. We're going to also do a video on negotiations down the road as well. I hope you found this informative. Our team of former prosecutors at the Bianchi Law Group's core values are courage, compassion, and commitment. Would love to be able to assist you, your family, your friends. If you have a criminal law matter, and even if not, these videos are instructive to you, help educate you about the process. We're more than happy and proud to be able to deliver that information to you. Be well.